We're looking at a report here that was released by the Bank of Canada for January 2017. Now, when we look into it, it's describing to us the credit that they have lent out. So we look and it says total household credit is $2 trillion outstanding. Of that $2 trillion, $567 billion is for consumer credit, and $1,437 billion are for mortgages, or is being used for mortgages. So in total, for household credit, not business credit, only household credit, there's over $2 trillion on loan from the bank. Now we flipped over, again, Bank of Canada report, released January 2017. Now we're looking into business loans, business credit that the bank has lent out. So we see that there's over $1.8 trillion on loan from the bank for business credit, business loans. This is the Bank of Canada report from 2015. I couldn't find the one for 2016 or 17. It doesn't look like they released it yet. So, as of December 31st, 2015, bank notes in circulation in Canada, real bank money, was $75,496,000,000. That's the amount of real money of bank notes that are in circulation in Canada. The $100 bill, the $50 bill, the $20 bill, the 10 and the 5, the 2s and the 1, and the change. Well, actually, it would say bank notes, so it would only be bank notes. It wouldn't be considered change. But there's $75 billion that are out there. So keep that in mind. So once again, just a quick breakdown. There's $1,842,000,000,000 on loan from the banks in Canada for business loans. And there's $2,400,000,000,000 on loan from the banks of Canada for household credit, household loans. However, in Canada, there's only $75 billion circulating through real banknotes, through real money. So there's over $4,242,000,000,000 that are on loan from the banks, and it's not real money. Because if we only have $75 billion in Canada as real money, yet there's $4 trillion of loans that are circulating around in Canada, what did the banks lend to individuals? Did the banks lend you real money, real physical Canadian dollar bills, real physical banknotes? Or was it electronic accounts, keyboard information that they place on their computers? The majority of us who walk into the bank have no idea what is transpiring behind the scenes and within the legal documentation that the bank presents to us. We are going to take a walk together through the experience of an interaction with the bank. The best way to understand what has transpired is to replay what actually transpires. By doing so, we will see where the bank is taking dishonorable actions with us, contracts with dishonorable actions. We have walked into the bank and we have approached the agent of the bank, seeking to open up either a checking or savings account with the bank. This is usually our first experience with the bank. At this point, we are introduced to the representative who handles this, and we are brought into an office. The agent of the bank will ask us what account we are seeking to open, a checking or savings account. She will then give her opinion as to what terms and conditions would better suit us. After we decide, she will present us with a 3-page document. Now, this 3-page document is titled or designated Financial Service Agreement. On this documentation, there is not much information besides what type of account you will be opening, the service fees you will be paying for the account number, and the branch number. What will not be on this documentation are any type of terms and conditions concerning the use of this account. The bank agent, who is simply following procedure, will now ask you to sign this financial service agreement, and you will do so. She will then leave the room, assuming it's a woman. She will then leave the room and return with something that is titled or designated financial service terms. It is usually a documentation anywhere between 8 to 14 pages long. This documentation, titled the financial service terms, will now explain to you what conditions you have agreed to by signing the 3-page financial service agreement. You have just entered into a contractual agreement, according to contractual law. However, there has been some illegal actions taken by the bank during this disclosure. A contract is an agreement of wills, and by signing the financial service terms, the bank is claiming that you and their party have come to an agreement. You have come to an understanding, and you accept the terms and conditions of this contract. Now, when we look into the Quebec Civil Code, Article 13.78, it explains us the nature and the operation of law that is attached to contracts. Now, a contract is an agreement of wills, so you both have to agree, by which one or several persons obligate themselves to one or several other persons to perform actions, to perform their promises. Quebec Civil Code, Article 1379. A contract of adhesion. Now that's a type of contract. That's the name of the contract. That's a designation, what type of contract it is. A contract of adhesion is a contract in which the essential stipulations, the terms and conditions, were imposed or drawn up by one of the parties on his behalf or upon his instruction and were not negotiable. And this is the type of contract that the bank is using with you. When you walk in there, they present you a contract of adhesion. The financial service terms, which they give to you after you sign, you have no ability to negotiate with them. They draw them up, they produce the rules, and then they say, here, you are obligated to this. This is what you agreed to when you signed the documentation. The contract that the bank has presented to you and made you sign upon without disclosing the terms and conditions was a contract of adhesion. The terms and conditions were drawn up by the bank alone, and there was no room for negotiation on your part. This is the type of contract that you have entered into with the bank. However, the bank never disclosed any of the terms and conditions to you before asking you to be bound to the contract. They never disclosed any of the terms and conditions to you before they asked you to sign and say that you agree to them. Again, looking into the Quebec Civil Code, looking more specifically with the articles of law that deal with contracts and how contracts are formed, Quebec Civil Code 1388. An offer to contract is a proposal which contains all the essential elements of the proposed contract. It contains all the terms and conditions that they want you to be bound to, and in which the offerer signifies his willingness to be bound if it is accepted. As you can see, an offer, the contract, the proposal, it must contain all the essential elements of the proposed contract, meaning that the terms and conditions must be included and disclosed to you within the contract, and if they are not, there is no way you can be held liable or accountable to these obligations, for there was no disclosure. The bank never allowed you to read the 14-page document titled Financial Service Terms, which explain all the essential elements of the contract that you were agreeing to. Legally, the bank has the obligation to show you this and allow you to read it prior to you signing the financial service agreement. Only by taking such actions can the bank claim that they have given you full disclosure. Since the bank failed to disclose the nature or terms and conditions of the agreement, you cannot be legally held accountable to these terms and conditions. The bank never disclosed the terms and conditions to you, and now they're asking you to be held liable to these terms and conditions. Contract law does not work that way. In order for a contract to be legally binding, and in order for a contract to be acceptable, to say that you consented to the contract, they must disclose the terms and conditions prior to you agreeing. You cannot say to them, yes, I agree, and then afterwards, once you've agreed, and then present to you the terms and conditions. This is not a a validly formed contract if someone does this to you. Looking at the first page of this documentation titled the Financial Service Terms that is given to you after you sign, you will find the following indication written within this documentation. In the opening declaration of this documentation, it declares that the terms and conditions that are described and brought forth in this document form the agreement between you and the bank. So you see what they did? They get you to sign first, then they present you a documentation and they say to you, you agreed to these terms and conditions, here you go. Then they further remind you and state that you signed our financial service agreement and therefore you are bound, you are obligated to the terms and conditions indicated in the financial service terms. Again, backwards operations of law. You cannot present to me terms and conditions of a contract after I've signed them. You are under obligation to disclose all the terms and obligations within that contract before I can give you consent. If you do it in this way, if you take my signature, my consent, and then present me the terms and conditions, then I was not free and enlightened. I did not know what I was going to agree to. Therefore, that contract will not stand against me. So what has just transpired here in your interaction with the bank agent is totally against contract law. In a contract, an individual must be given the time to study, read, and understand what the contract is declaring or binding an individual to. In order to agree and legally be bound to terms and conditions in the contract, you must have been given the chance to read them and understand them before you accept them. If you accept them without having been given the chance to read them and understand them, then this is not free consent. The bank agent did not give you a chance to read the terms and conditions of the contract you are entering into prior to signing the agreement. She had you sign the documentation first and then afterwards presented you with the terms and conditions of the account. This action voids your consent and your agreement to the terms and conditions. You cannot be held liable to those terms and conditions, for they were never disclosed to you, and when you signed the documentation, you signed without the bank agent having revealed the terms and conditions prior to asking you to sign. The bank's action is against the law. Now, you never voluntarily offered to sign that document at first. You didn't have the 3-page document in front of you and say, okay, I'm going to sign it, here you go. It's the bank agent that actually asks you to sign that documentation first. That's the procedure. So when you're sitting there and you've got the financial service terms agreement with them before you, you read it, you choose the account, you understand what rates you're going to pay on the account, then she says, okay, sign it. Or he says, okay, sign it, and you sign it. Then they pick that up, they walk out of the room, and they come back with that 14-page document, and they say, here you go. This is what you just agreed to. And again, that's not full disclosure, and you didn't have my free and enlightened consent when you did that to me. The contract and the conditions you agreed to will now be the foundational document that governs your interactions with the bank. Whatever you agreed to by signing this financial service agreement, this becomes the law between you and the bank. And they place that right within the documentation. Here's the statement. By signing the financial service agreement, you agree that any existing agreement between you and us for any particular product or service is replaced by this agreement. So what did you just do? You basically agreed to be bound and be governed by the financial service agreement, and you did not even have a chance to understand what you were binding yourself up to. You weren't given the chance to read and see what exactly are the terms and conditions, but now the bank is going to further state that this agreement that we came to through this wrong operation of law in contract law is now going to govern all our interactions between one another. So if you have a credit card, this existing agreement will be priority. If you have a loan with us, this existing agreement will be priority over all existing agreements. Now remember, we learned in the Quebec Civil Code in Article 1433 that a contract creates obligations, and in certain cases it modifies or extinguishes them. In some cases, it also has the effect of creating, transferring, modifying, or extinguishing real rights. So a contract can be created, and the terms and conditions of that contract, it has the effect of creating, transferring, modifying, or extinguishing your real rights. Yet again, they don't allow you to investigate the contract. They don't allow you to read the contract to see, hey, what am I signing? Am I modifying any of my rights? Am I transferring any of my rights to the bank? Am I extinguishing any of my real rights? No chance to investigate. Just signed upon the document. Now we're in agreement. Every interaction you have with the bank from this point forward will now be stemming or flowing from or coming from the terms and conditions of this documentation. May I ask how many of you watching this video are aware and have read and are familiar with the documentation that the banks are holding you to? Again, I want to make it clear that before anyone can claim that you have a liability or obligation to certain terms and conditions of a contract, they must have been revealed prior to accepting the contract. Now we're going to look at just one of the terms and conditions that the bank had you agree to when you signed upon that document and they presented the contract to you after you signed. You had your checking account or savings account open for about a year now. You have been pursuing and earning a living and using your account to cash your paycheck that you receive for that living. You decide that you will apply for a loan with the bank. The bank accepts your application and grants you the loan. Great. Party time for some of you. The bank is claiming that you agree to the terms and conditions of the contract and that you allow the bank to apply a positive credit to any of the accounts, any debt, any obligation or liability that you may owe to them. They claim the right in the terms and conditions of the contract to set off the balances that you may owe to the bank in any manner they consider. When they decide and choose to set off these balances, they are not required to give you any notice. Now that's a condition that the bank took from you. They are claiming you agreed to this. You gave them the power, you gave them the authority to take such actions with this account, even though you never knew. Now this is exactly what is written in that documentation. Set off debts against your account. We can apply a positive credit balance in any of your accounts with us against any debt, obligation, or liability you may owe to us. We can set off these balances in any manner we consider necessary, unless we have specifically agreed not to do so, and we are not required to first give you any notice. Now notice when they're talking about debts, okay? They say we can apply a positive credit balance in any of your accounts with us against any debt. They didn't say they're going to pay it off, right? As me and you would think about paying off. They said if you have a loan or a credit card, a debt against them, that they can apply a positive balance to this debt and set it off. Well, if you understand what that's saying and why it's saying that, we just saw that there's over $4 trillion of loans in operation in Canada. However, there's only $75 billion of real banknotes in circulation in Canada. Those $4 trillion of loans that are in operation are nothing more than bank balances on a computer. It's not real physical money. So when you have a debt with the bank, this debt is indicated on their computer records by an obligation, a liability in your name. There's an account that is in the negative and says you owe that money. Now they can come along and they can apply a positive balance, a positive credit to that negative account and put it to zero and set off the debt and not tell you that they've done this. This is a right the bank claims you gave it. Remember that credit card that the bank allowed you to acquire with them? Well, they gave you $20,000 on that credit card and it's all been spent up. You've lost your job and you cannot afford to make payments anymore on this card. 3 months have passed by and you have not made any payments on this card. Guess what? They're going to call you in default and they're going to send you to the collection agency and they're going to try and come after you. However, the bank can apply a positive credit, set off the balance of this account so that their books do not look like they've lost anything. They can further transfer this obligation, this credit card balance, to a collection agency, never informing you or the collection agency that they have set off this balance. The collection agency will treat this contract as a contract that still has obligations upon it. They will threaten you and will take you to court to try and secure the judgment. The same operation of law will transpire with the loan. Household credit, the loans we saw. When the bank agreed to provide you a loan, let's say for $60,000, what they didn't inform you was that you are actually creating a negotiable instrument, a valuable instrument for the bank. What transpires is that when you are accepted for the loan, 2 transactions take place upon the record of the banks. The first transaction is the bank indicates in their electronic records that they have received a positive increase within the bank's overall balance for the amount of $60,000. A loan is actually a promissory note, and promissory notes in Canada are money. If you look upon the documentation that you received from the bank for your loan, it will actually be indicated upon it that it is indeed a promissory note. Upon completion of this promissory note, the bank considers their assets increased by $60,000. So, for example, you will go to the bank, you apply for the loan, you're accepted for the loan, then they deposit the funds into your bank account, and then you have access to those funds. Now, when they deposited those funds into your bank account, what happened was, in their books, they gained that asset. So if it was a $60,000 loan, and then you go to your checkings account and now you have the $60,000, well, on one side of the bank's records, their assets have increased by $60,000. That deposit increased the bank's overall assets by $60,000. Now, the second transaction that takes place is an electronic debit is produced upon the bank records. Now, this is nothing more than an account that is opened under your person's name with the indication of minus $60,000 in the account. So they open up a second record, a second account, and in it they say, John Smith owes minus $60,000. Now, for example, if your payments were $1,000 per month, every time you made a payment, the account would be credited, or a positive balance or a positive credit of the amount would be applied to the overall amount that is due. So minus $60,000 in the account, you made a payment of $1,000. Now the account goes to minus $59,000. So now it's minus $59,000. You made another payment of $1,000. Now the account is at minus $58,000. Again, minus $58,000. You made a payment of $1,000. So now it's minus $57,000, and so on, and so on, and so on. This will transpire until the account reached zero. Then the account would be closed, and you would have no more liability towards this account. The bank, however, will still have the asset of $60,000 that was deposited into their overall assets through the promissory note. So you will have increased the bank's assets without you even realizing it. Now, let's say, somewhere along the lines, again, you lost your job. This sounds more like a realistic story than a made-up story, the way the economy has been operating over the past few years. But anyways, let's continue. So you lost your job, and you still owe $45,000 on that loan. Now, the bank can apply a positive credit to that account and bring that account balance to zero. Remember, in the service terms and conditions, you gave the bank the permission to do and take such actions when you opened up the checking or savings account. You gave them the permission to apply a positive credit against any debt, liability, or obligation you may have owed them. You gave them the right to set off these liabilities without having to notify you that that is what is transpiring. So when we go back and we look at the actual service term and condition that's in the actual document, again, we can apply a positive credit balance in any of your accounts with us against any debt, obligation, or liability you may owe us. So they can apply a positive credit, a positive balance to the account. So here, you owe them the money, minus $58,000, and they apply a positive credit to the account, and they bring it to zero, and they set it off. And now under books, there's no more liability. There's no more loss of this money. There's no liability on their book anymore, only the asset that you created through the deposit. But that's why the service terms and conditions brings it out like that. It doesn't say we will pay off any of your debts, because they know what they're doing. It says we can apply a positive balance, a positive credit. Yeah, because it's not real money that's being played with here in Canada. When you come into default, whether for a credit card, or a loan, or a mortgage, and the bank sends you a letter, threatening letter, you need to return a communication to the bank asking them if they set off the account. If the communication comes back to you, and in the communication it is indicated, no, we have not set off the account, then you can bring up the service terms and conditions of the contract that you signed and agreed to, that the bank is playing with, and bring to their attention to the point where they have the right to set off these accounts. Inform them that you want them to invoke this right and to apply a positive balance to these accounts. Within the communications to the bank, you will inform them that you understand all that transpired, basically what you are learning here today from this video. The bank never put up any consideration, any asset for this loan. As we saw, it's nothing more than accounts being created on the computer. For the bank to go into a court of law and declare that they have lost something, that you have caused them damage and loss, in my opinion, is fraud upon the court. How can they walk in there and say, oh, I've been damaged, I've lost something, if what they put up, if what they put forward was absolutely nothing but keyboard strokes on a computer? Now, if I lent someone $100, Canadian dollar bill, and they said to me, I'll pay you back in 2 weeks, and 2 weeks passed by, and I went to collect that money, and they were nowhere to be found, and a month passed by, and they were still nowhere to be found. Guess what? I've been damaged. I've lost actual something real. The bank is playing with nothing more than electronic records. Now remember, even more so, considering the fact that the bank has the ability to set off these loans, which under law causes least damage to both parties. So they have the right, they have the ability, on the term and condition, to set off these debts, to make themselves whole, to make you have no more obligation to them, and it's the least damaging to both parties. Not only that, they also received an asset through that loan. Remember, when they deposited into your account, it became an asset for them. So once they set off the liability, then they have an asset for the bank. Remember, this also applies to mortgages. When a person applies for a mortgage at the bank, the same transactions are happening. They say the mortgage is for $400,000, let's say. There are two transactions that are recorded within the bank records concerning this mortgage. The first being a positive increase in the assets of the bank, which will take place in the amount of $400,000, and subsequently an electronic account that is debited or indebted to the amount of $400,000 plus interest, and will be brought into existence under your person's name. Every time a payment is made upon this mortgage, the overall negative balance of this account is increased until it reaches zero and the account is closed. Now, if you want to verify what I'm saying here, if any of you are presently going through credit card or loan arguments with your bank and the collection company is coming after you or is actually taking you to court and have sent you the records that they plan on using in court, go and check the records that they're going to use in court to prove that you owe the liability, to prove that you owe the obligation. You're going to see it's an account with your person's name on it, and it's going to be indicating minus, we're going to stick with $400,000 here, it's going to be indicating minus $400,000 at the top. And then your first payment, let's say it was $1,000, it will say minus $399,000. And it will keep going that way until you default it, until you stop paying. So even their proof, even their evidence that they tried to bring to court is showing forth exactly what the bank is doing. The account that the bank is creating on behalf of your person's name is an electronic debited account, indebted account. That's what it is. And that's why those records that are brought to court show this. Now the bank will still have the asset of the $400,000, plus they will be able to apply the multiplication factor upon this amount.